I'm going to present Island of Palmas case between Netherlands and the US, main issues in the case according to the United States argument. Wood's letter to the US on 26 January 1906 and the certificate issued by the first Lieutenant Gordon Johnston on January 21st to the natives inspected by the Sangi and Tolawa Islands controllers clearly indicate that the visit of January 21st relates to the disputed island. The visit led to the declaration by the US that the islands of Palmas certainly included in the archipelago known as the Philippine Islands as described in Article 3 from the Treaty of Peace between the US and Spain, also known as the Paris Treaty, and ceded to the US by virtue of that article was considered part of the territory of its possession in the East Indies by the Netherlands. Being the heir to Spain's sovereignty over the Philippines, the US bases its title on conquest. The presence of sovereignty thus acquired was not merely verified by the most reputable cartographer and writers, and also by a treaty, in particular the Monster Treaty of 1648, which both Spain and the Netherlands agreed. At the time Spain relinquished its title to the Philippines by the Treaty of Paris in 1898, the US fought for the latter title. Accordingly, it was needless to create facts showing the actual display of sovereignty over Palmas Island. Ultimately, the American government maintained that Palmas is a territorial member of the Philippines nation and is closer to the Philippines than to the East Indies. We're moving to the Dutch argument. The Netherlands considered that the reality of Spain's finding was not confirmed and kept the same for other accusation type. According to the Palmas Island Arbitration 1928, the established state of affairs was stated to have been validated by international treaties, and the inquired title asserted by the US prevailed over a continuous and peaceful shows of sovereignty that the Netherlands exercised and contiguity title established in international law. The arbitrator noted that the legitimate transfer of territory through cession was not invalidated by any new international law. The arbitrator acknowledged that Spain could not legally grant anything it did not possess, and that the Paris Treaty could not award Palmas to the US because Spain had no clear title to it.
Within the case of Island of Palmas, many laws had to be taken into account when conducting the trial. Based on the case, more than 10 laws had to be referred before making the decision. So, some of the laws that are involved or that are being used are the Arbitration Convention, Special Agreement Act, Treaty of Paris, Treaty of Munster, Treaty of December the 10th, 1898, the Hague Convention 1907, Treaty of Utrecht, and also the Charter 1602. So, however, within this case, within our assignment, we only referred to two of the most important laws that are being used within this trial, which are the Special Agreement Act and also the Treaty of Paris. Okay, so within the Special Agreement Act, the articles that are being referred to are Article 1, Article 2, Article 3, Article 4, Article 5, not Article 6, Article 7, and Article 8. So those are the articles that are being referred to when they are conducting the trial. So Article 1 basically explains about which country have the rights to the island, and the decision must be made by the arbitrator with the presence of both parties. Next, Article 2 talks about the Netherlands' point of view towards the American application. Article 3 describes about the application of both parties' desire to make a rejoinder, to extend the period for each country to submit their evidence. So they need all the time to submit more evidence. Okay, so next is Article 4 and Article 5, which basically states that the trial must be held in English. The language that must be used by the arbitrator is English. Okay, so Article 7 talks about the 3 copies of the award are deposited with the International Bureau of Permanent Arbitration. So finally, Article 8 of the Special Agreement Act is about the pricing of procedure, which is around 120 euros. Next, law that had been used is the Treaty of Paris. So within Article 3 of the treaty, it stated that Spain had agreed to transfer all rights or sovereignty which they may have possessed to America. Furthermore, this law was relevant for the arbitration because Spain had possession of the island of Palmas, as it was included with the Philippines island.
Point number 1. A necessary solution for this ground would be under special agreement in Article 1, in order to decide the argument to be decided by the arbitrator. The present case implies that the island of Palmas belongs either to the US or the Netherlands. Agreement of January 23, 1925 object to suspend the dispute. The supposed will of the arbitral parties is not to be finalized by the arbitral party. A non-decreed even so, in any event, the island is a part of the other territory or to litigant power. On to the third point. The island of Palmas did not develop any portions of any state territory under Treaty of Paris, as Spain only have rights from the discovery and contiguity of the island. Moreover, the title of Netherlands could not have been changed by a treaty between third powers that could not have influenced the character of illegality of any act undertaken by the Netherlands. Next, each party has been only a limited part of the evidence relating to the period immediately preceding the state of the dispute. The parties must impose themselves with greater force to be taken into account. Lastly, the arbitrator considered there were no unchallenged act of peaceful display of the Netherlands' sovereignty in the period of 1700 to 1906, and this will be seen as a sufficient demonstration of the presence of the sovereignty of the Netherlands. Reasons are that the arbitrator is in compliance with Article 1 of the Special Agreement of January 23, 1925, decides that the island of Palma forms in its entirely a part of Netherlands territory.
Our opinion towards this case is positive. The outcome of this case is positive. Why? Because the arbitrator is not biased towards either of the parties that are involved. Before deciding who are entitled the sovereignty of the island, Max Huber thoroughly investigated all the evidence by both parties and made his decision based on the international law, which means that if the evidence that was provided was not sufficient in the face of international law, then it has no validity to prove that the island was part of either countries. So the decision was based on the validity and not on the biasness towards either parties.
I'll be talking about the Pedra Branca dispute. The dispute over Pedra Branca was a territorial dispute that happened between two states in the Southeast Asia, which is Singapore and Malaysia. It was a dispute over a few tiny islands that is located at the east side of Strait of Singapore, which is known as the Pedra Branca, the South Ledge, and the Middle Rocks. The main issue in this case for Singapore's argument is that it was claimed by Singapore that the island was terra nullius, which is also means as no man's island. Other than that, the government of Singapore also stated that there was no proof that Pedra Branca was under Johor Sultanate rule. In the case, the ICJ did not acknowledge this argument, which Singapore then argued that the state of Singapore and the British clear assertion of control over the territory was the reason for the pass down of sovereignty in the island to them. The clear assertion of control mentioned comprised of the action of selecting the site as well as the development of the lighthouse itself. Other than that, also includes the requirement to have permits for any Malaysian officials who wants to pay a visit to the site, constructing the island's military rebroadcasting stations, and also researching about the possibility of recovering territories around Pedra Branca. Meanwhile, the Malaysian government remained passive in regards to those activities. Furthermore, it was reported in a letter from the year of 1953 that the Johor state never declared any ownership or sovereignty over the territory, and had released a formal statement and maps during the time suggesting that Pedra Branca was a part of Singapore. Moving on to the main issue in the case from Malaysia's argument. The case for Malaysia was that Johor originally had the sovereignty over the territory and claimed that Johor never ceded the island off to the British, but had simply given the permission for them to construct and preserve the lighthouse thereon. The UK and Singapore's action regarding the Harrisburg Lighthouse and area around the Pedra Branca territory were not acknowledged as action of sovereignty. To further explain their stance, they also stated that the letter from the year 1953 was not legally authorized, and the formal statement, as well as the map that were published at that time, were considered as not relevant and vague.
Okay, so the document that consists of laws that both parties need to abide to is known as a special agreement. It has a total of 8 articles, so I'll be going through one by one. Article 1 states that both parties agreed to present the dispute to the court. Article 2 asserts that the court is required to decide on which of the parties hold sovereignty over the 3 islands. Article 3 states that the names that shall be used throughout the process, which refer to Pedra Branca, are not considered relevant to the question of which country holds sovereignty over it. Article 4 asserts that the proceedings shall comprise both written pleadings and oral hearings. And according to Article 5, the doctrine that is used in the case will be the one that is established in Article 8 of this in the Article 38 of the Statute of ICJ. Article 6 stated that both of the parties agreed to accept the court's judgment in accordance to the special agreement as binding upon them and final. And according to Article 7, the special agreement will be effective after there is an exchange of ratification instruments on a specific date that shall be determined using diplomatic mediums. And lastly, Article 8 stated that the notification of the special agreement to the registrar of the court shall happen as a result of a joint letter from the countries shortly after it has become effective.
As Malaysia and Singapore have been incapable to resolve the matter through bilateral negotiations, both countries have agreed to resolve their dispute peacefully over a third party by bringing the case to the International Court of Justice. On 23 May 2008, the ICJ ruled sovereignty of Pedra Branca goes to Singapore, the sovereignty of Middle Rock goes to Malaysia, and sovereignty over South Ledge goes to the territorial waters of the state. After the ICJ's judgment was released, both Singapore and Malaysia agreed to go by ICJ's ruling. They have formed a Malaysia-Singapore Joint Technical Committee to implement the ICJ's ruling. Between February 2017 to May 2018, there's been quite a few number of exchange of file applications for revision of the case, written observations as well as written comment from both parties. On 29 May 2019, the ICJ informed Malaysia and Singapore that the court had recorded with sets of reports instituted by Malaysia against Singapore for discontinuation, which is agreed by both parties, and therefore directed the removal of the case from the list of the court.
For the outcome of the judgment, the outcome is considered positive and not biased. It benefits both Singapore and Malaysia because the sovereignty over Pedra Branca was awarded to Singapore and the sovereignty over Middle Rocks was given to Malaysia. The then Foreign Minister of Malaysia, Rais Yatim, stated that the decision made by the ICJ is beneficial to both countries. The then Deputy Prime Minister of Singapore, S. Jayakumar, said he was pleased with the judgment. And because of this, both countries were able to form the MSJTC to outline the boundaries around Pedra Branca region, Middle Rocks, as well as to decide the legal ownership of South Ledge.